This is part 2 of evidence, relevance of evidence, 401. Evidence is relevant if it has any tendency to make a fact more or less likely, and that fact is material. Direct evidence is evidence that is identical to the factual proposition the evidence is offered to prove. If the factual proposition is that the defendant shot the victim, then direct evidence is where the witness testifies that the witness saw the defendant shoot the victim. Circumstantial evidence indirectly proves a factual proposition through an inference from collateral facts. Again, a factual proposition being that the defendant shot the victim. Circumstantial evidence would be where the witness hears a shot, comes into the room, sees the defendant over the victim holding the gun. Exclusion of relevant evidence. This is Rule 403. Evidence may be excluded for unfair prejudice, confusing the issues, misleading, undue delay, that it's cumulative. Now, this is different from the exclusionary rule from criminal procedures, where evidence obtained in violation of the Fourth Amendment rights will be excluded. And again, that's covered in criminal procedures. Laying a foundation in regards to tangible evidence. This is explaining where the tangible evidence came from and what it represents. Character evidence is covered in Rule 404. Character evidence is found in Rule 404. This is generalized information about the plaintiff or defendant's behavior, such as they're a bad parent, inattentive driver. Character evidence is generally inadmissible to show a party acted in conformity with a trait. An exception is in the civil context in a claim involving sexual misconduct. This is from Rule 413. In a claim involving sexual misconduct, evidence of the defendant's past sexual assault molestation may be admissible. Past conduct may also be admissible where character is at issue, such as a defamation action, child custody action. When admissible in the civil context, character evidence may include conduct, reputation, and or opinion. Again, only in the civil context does it include conduct, reputation, and or opinion. Character evidence in a criminal context, there is an exception. It's generally inadmissible again. However, if the defendant opens the door, meaning they offer evidence of good character, the plaintiff may rebut by attacking character. In the criminal context, this differs from civil. When admissible, character evidence may only include reputation and or opinion. Conduct is not admissible. So if a defendant opens the door, they may only offer evidence of good character by reputation and opinion. Plaintiff may then only rebut by attacking character using reputation and or opinion. Character evidence of the victim, the defendant may introduce if relevant to a defense, and again only by reputation and or opinion. And this might be the victim's trait or tendency towards violence to support the defendant's self-defense claim. The plaintiff may only offer character evidence of the victim once the defendant has opened the door. In regards to bad acts are not admissible to prove character and or criminal propensity or that the defendant committed the crime charged. It is admissible, bad acts are admissible under Rule 404 to prove motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, lack of accident. So bad acts generally not admissible to prove character, criminal propensity, or that they committed the act, but almost everything else. Habit evidence, this is Rule 406. Habit is routine reaction to a specific set of circumstances. Habit evidence is admissible under Rule 406 to prove that the defendant acted in accordance. There is no need for corroboration or an eyewitness. Moving on to witnesses, under Rule 601 and competency of witnesses, witnesses are generally presumed competent. Mental competence goes to the weight of the evidence, not the admissibility. Under Rule 602, the witness must have personal knowledge. The non-expert witness must have personal knowledge to testify. Children as a witness depends on their intelligence and or ability to differentiate between truthfulness and or falsehood. Impeaching a witness is where you challenge the witness's character for truthfulness, bias, and ability to perceive and or testify accurately. Now, the witness may be impeached by another witness or by contradictory evidence, and under Rule 607, any party may impeach a witness. You may impeach your own witness if you would like. The witness's character for truthfulness, looking at impeachment, the witness's character for truthfulness may only be bolstered after it has been attacked. Here again, the witness may generally not be asked about specific instances of conduct, but the witness may be asked about them on cross, except for arrests. Looking at arrests and the witness's criminal convictions to try to impeach the witness, this is under Rule 609. There is a 10-year limitation. Anything greater than 10 years is inadmissible to impeach the witness. Any crime involving dishonesty or false statement is, or if the crime does not involve dishonesty or false statement, it is admissible to impeach the witness if it is punishable by death and or imprisonment for greater than 1 year, and that must be greater than 1 year. And that concludes Part 2 of evidence.